you don't mind, if you can introduce yourself and then feel free to share your screen, we'll finish out at about 1:45, the top of the hour.
Excellent. As I'm getting things up, I'm gonna ask let's get some chat interaction going. If you've ever wondered about getting a patent, um, put one in the chat. If you filed for a patent, but didn't get one either because the USPTO rejected it or you abandoned it for whatever reason, put two. Or if you've had a patent, um, if you've received a patent from any patent office or multiple patents, put three. Okay, one and two, nice. Excellent. As those are starting to come in, let's jump into this. My name is Andy Godsey. I am the CEO of Summit Venture Studios. I also founded the Inventor Playbook for reasons that we'll get in here. So I spend a lot of my time with the Summit crew here on this call, and a lot of my time with inventors, helping them figure out how to commercialize, what they've created. I'm not a lawyer, as I put there. I get myself in a decent amount of trouble with patent attorneys for things that I say. So I've invited my good friend Andy Gabriel to hang out with me today. Say hi, Andy. Are you on mute?
Hello. Hello.
Andy is an attorney, so I've made it very simple. We're both named Andy. You can yell something at us. One of us will respond. If it sounds like a legal question, it'll probably be Andy Gabriel. Andy Gabriel has his own practice where he primarily prosecutes patents, helps people get patents, and develops strategy for getting those patents. And he also works for Vitech, which is a leading patent monetization firm, as the director of IP over there. Both Andy and I have been recognized as world-leading IP strategists and have worked with the world's largest companies on helping them define their IP strategy. So with that in mind, let's jump into what we're going to talk about today. Sorry, I'm getting my notes here. So just a high-level agenda. Want to talk for a minute about what's at stake with provisional applications, and apologies for leading you a bit on false pretenses. We'll talk a lot about provisionals, but we're also going to talk about just patents in general and what makes them valuable. So we're not going to get into kind of a survey course of provisional patents and all the timing and the fees and things like that. There's a ton of resources out there that's readily available. If you have questions, feel free to put them in. We can attempt to address them. But goal here is really to talk about deeper level understanding of why am I pursuing a patent? How do I do it effectively and come out with something that's most likely to be valuable? So we're going to talk about what's at stake, a bit of a nightmare scenario. Then we'll jump into how to prepare yourself when you're pursuing a provisional. Then we're going to talk a little bit about what makes a patent valuable, and then debunk some common myths that people have with patents, because it always amazes me the misunderstandings that people have about patents, and I'm in no way criticizing the people with those misunderstandings. It is a very complicated system. It should be easier. It's very easy to misunderstand, and so addressing some common myths that are out there can help you how to spend your time and resources. So with that in mind, let's jump into kind of the nightmare scenario. So there was a company, it's a bit of a famous case study called New Railhead Manufacturing. And what they did was specialized in drilling techniques used to install pipelines, cables, and conduits without having to trench. And so they filed a provisional patent application trying to secure an early priority date. And then they kind of got to work. In the meantime, before they filed their non-provisional, a competitor, Vermeer, began selling something similar to what was described in their provisional application. So Vermeer's in the market, selling product, making money. New Railhead then finishes, they go ahead and file their non-provisional application, and then eventually it gets granted into a patent, and they sue for patent infringement. And so they're in a litigation case, and Vermeer challenges the patent, a new railhead patent, by saying uh, they didn't disclose this specific thing. And it was something about having to do with, one second, I've got a note here. They didn't disclose using the tool in rock formations. And because they didn't mention that in their provisional, the court agreed. And so they lost the case. They lost their claim to an early priority date. And the kicker there is now the Vermeer product became prior art. And so actually their patent was invalidated. So this is a scenario where they filed something first. They did everything they thought was to be right. They put their idea and their invention out there in the market, and then they walk away with nothing. And so they've spent the money, they spent the time, the resources, and they've also probably educated a decent amount of competitors about how they were approaching it. Nightmare, worst case scenario. So this is kind of what's at stake, right? When a lot of times I hear inventors or entrepreneurs talking about filing provisionals, and they say, I'm going to self-file, which is totally fine. I'm not saying you shouldn't self-file, but it's a bit haphazard in their approach. And it's a dangerous game, right? Unless you're just using that, which a lot of people do. If you're using it to raise money and just being able to point to the patent pending, that's fine. That buys you a little time. You can do that. But if you have any hope that this will become a valuable asset one day and important to your strategy, you have to put more thought and care into it. And so just a weak or incomplete provisional can really destroy your patent rights. And so you really need to be thinking about this, or you should understand the game you're playing, or just don't play it. Right? That's also an alternative that's very reasonable here. Just don't pursue the patent because it takes up a lot of time and energy. So with that in mind, with that case study, let's jump into talking about what to disclose. So the thing about the patent system, and every patent system around the world, right? It's really a trade-off. It's a bargain that you're making with the patent office. The government wants innovation. They want to use it to drive economic growth, to solve problems. They want you inventing. So they're willing to give you a monopoly for the thing that you invented if you're willing to tell people how to do it. That's the trade, right? So in order for that trade to make sense for the patent office, you have to disclose it in enough detail so that someone that's familiar with the space could reproduce what you've done. And that's when you think about that for a second, it's kind of intense. And I think people should think about that more. And I think you are starting to see a trend. And actually, Andy, I'm curious if you see this. I've seen a trend of people talking about trade secrets more because they're not comfortable with this bargain, right? They say, no, I'm confident that I can keep this under wraps, and I'd rather protect my secret sauce here rather than disclose it. Andrew, have you seen that trend?
Yeah, for sure. And that's something to take into consideration. And I think there's not a right answer, but as long as it's a conscious decision, then that's fine. But yeah, a lot of people are a little bit surprised that the applications will be published unless you put in a non-publication request, and then at 18 months from priority, basically anybody can read your disclosure, and whether you've got a patent on it granted or not, the information is sitting there and available. Yeah.
So it is absolutely a bargain, and one that hopefully benefits society in the long run. But it's something that you as an individual should consider. And so when you're disclosing, when you're filing this provisional, you need to make sure that it's enabling, right? That you're going to enough detail to describe how to do the thing that you want protected. And you also have to be thorough. And Andy, I'm going to punt it over to you here in just a second, just as a heads up, so that you can talk a little bit about what you feel like should be disclosed from your perspective. But one thing I'll talk about here, and we'll come back to it a little bit later, is this is a great place if you're doing this on your own to use AI, not to completely outsource, write my provisional patent, but to really test and make it more robust so that you can consider all of the different ways that this might be used, so that you don't end up not filing for something that would be used in the tool in a rock formation, which ends up being pivotal later, and you end up losing the priority claim. But Andy, what from your perspective, what should someone be looking for? What's some general advice about what to disclose here?
In terms of making the disclosure adequate, I think, keeping the fundamental rule of this bargain for exchange of the patent system in mind is a good guiding light. So that means you're really supposed to teach through the patent document how to make and use the invention. If you're doing that, then you're meeting your end of the bargain, and that's something I think to keep in mind generally. The other thing practically I'll say is there's always going to be a tension between cost and speed versus thoroughness and completeness in this area. So the best practice is to have the provisional look just like the regular application. If you could do that every time, that'd be great. It'd be fleshed out entirely and all the examples would be there. A lot of times that's not possible because they don't exist or you don't have the money to do that. And so you make some trade-offs. And again, I don't think there's a particularly perfect right answer, but as long as you go into it consciously knowing that there are some trade-offs, I think you'll be in a better position to make wise decisions about what am I filing? What are the potential pitfalls? What am I getting for this cost expense and that sort of analysis? So that's sort of where my mind goes. The best practice is to just do the regular application. And then if you can't, then you're backing off. And just so you know, when you back off, you take on some additional risk, because you're cutting corners essentially. That's sort of the way I think of it.
Yeah, and so this is one of the things where someone asked a question here, and we'll try to get to this if we have time at the end about how much money. So filing provisionals is actually really not that expensive. If you're a really small entity, a couple $100s, right, for the filing fees, then obviously your time and whatever to prepare it. But there's this risk of having someone with the expertise that can walk you through about how to make sure that you are properly disclosing. And it really depends, again, how do you plan on using this asset? If you're just using it so that you can point to patent pending, maybe not super important if you're never planning on filing a non-provisional. But if you are, it's always a good idea to at least consult with a patent attorney and see if it makes sense to engage. So just some key risks I want people tracking here. About there's definitely a line to walk here. So if you got an inadequate, if you file too early, you can risk an inadequate disclosure, and then you're not disclosing enough, so you get this weak or invalid patent. And you also really risk out on something that as I spend more and more time with startups, the validation process is so pivotal. Getting that feedback from customers about what actually is the thing that matters in your invention, what is driving people to your solution. You file too early, you may miss that completely. And that's not to say you can't file another one, right? You can file multiple, but that just starts to ratchet up the costs and also the distraction. But filing too early comes with a risk. Filing too late. I'm going to jump to the second one, Andrew. I'll let you talk about the first one here in a second, but you can lose. The U.S. transferred to a first-to-file system. I think it was back in 2012. And before that, it was really a mess. You could argue, oh, I actually invented this first, and you'd try to show document trails who invented what. It's not that way anymore. If you filed first, you get the invention. Now so there is a risk of waiting too long and someone sneaks in and files before you. It's a very real risk that you need to track. And also, as we saw with the case study, increased market activity creates prior art, right? And where there might be more public disclosures, the longer you wait. So if it's an active field, that's something to be concerned of. And also specifically with foreign filing. So in the US, when you first publicly disclose an idea, if I write here on Midday Connect had an invention and I told you, that would start a clock. That would create a year for me to be able to file a provisional or non-provisional application. That's in the US. In a lot of other countries, any public disclosure bars you from filing. Now I'm going to go ahead and ask Andy if that's true. I'm pretty sure that's true. You're on mute. Don't say it's complicated.
I knew it was going to happen one time. Yeah, it's too complicated. Every situation is different, and I'd be glad to give you a thorough answer if you would just retain me as your personal lawyer. Because the first slide said I'm a lawyer, not your lawyer. So anyway, generalities. Speaking of generalities, yes, the best practice is file the patent application first, tell people about it second, offer it for sale second. So you want to really have that, ideally have that filing date ahead of any of this sort of activity. In the US, you can get away with it a little bit still. There is a grace period even after the American Invents Act, but they've necked it down a little bit. But in generalities, yes, you have a year to do these sorts of things and then file a patent application in the US. And it is also true that generally in foreign jurisdictions, that require absolute novelty, which means you have to file a patent application first, any of this sort of activity can potentially put your foreign patent rights at risk. So.
And I think, yeah, I'm not going to get into that now. I would push a little bit on the file first, then disclose. I think that's generally good advice. But I would be interested, as an entrepreneur myself, I'm interested in pushing on that and testing things. And is there ways to do that where you don't disclose the secret sauce, right? And trying to find that balance where you can still get that pivotal market feedback without disclosing the invention. And so there are ways, I think, to approach that, but it's risky. And so it's something absolutely you should talk with someone smart like Andy Gabriel before doing. So we're going to jump in here a little bit. We've got a few more minutes, and then we're going to open it up for Q&A. I always like to talk about what makes a patent valuable whenever these conversations come up, because again, I think it's important to understand the game you're playing. So here's some metrics that we look at when we're looking at a patent. When Andy and I used to work together a lot, large tech companies would hire us to review their portfolio. We'd look at how broad is this claim. We'd look at how relevant is this claim in the market. Does it cover important features that are in high demand? So is there evidence of use of this in the market? Can we document each and every element of the claim to a product that exists in the market? And how much is that product worth? And then how valid is this? And that covers many facets, but how strong is the priority date? The USPTO may have issued it, but many people know that doesn't really mean very much. It has a presumption of validity, but it's in this stage, it's fairly easily challenged. When someone challenges a patent's validity, in my experience, very rarely does a patent get through unscathed. It may just lose one claim. Sometimes it loses all the claim, but usually the USPTO is not doing a very thorough job currently. So defensibility is something we look at. Is it obvious? And did you miss any kind of filing dates or any kind of logistical things that may invalidate the patent? Something you need to look at. And the last thing is strategic positioning. And think about this more like, is it just one invention, or is it a group of inventions that are targeting something, right? That you're really creating a blocking position where someone can build on. Single assets are really hard to move and license, but the larger your portfolio gets, especially if there's multiple that have evidence of use, it becomes more value. So the reason I point at this is I don't think that there's a lot of thought into these value when every day I see a patent that is very clearly worthless. And I know that sounds harsh, but it's true. And I look at these claims and they're 500, 600 words long, and they're so specific. And I think there's no possible way that I could design a product that would infringe this claim. It just doesn't seem possible. And I submit to you and tell you that is a worthless patent, unless you're getting value of hanging it on your wall. And I don't want to tell you how to get value. So that's fine. If you want to hang the ribbon copy on your wall and say this was worth it to me, it cost me $15,000, but I'm very proud. That's awesome. If you're trying to use it to drive your business, to drive a sale, to drive licensing, it's worthless. And so you really need to be keeping these things in mind. And Andy and I could each, write a book probably on each one of these topics. So we're not going to be able to do that here. But these are things that are absolutely pivotal from thinking about from day one about your filing. Last thing, as we're kind of winding down, here's some common myths I think that people approach when they file their patents. A provisional protects my invention. A provisional is just a placeholder, right? It's important to get right, but it's just a placeholder. If you don't file the non-provisional later, it's worthless. There's nothing you can do with it. I have a lot of people coming to me trying to sell provisional applications. There's just no value in it. There's just no value in it. So it's never examined, it's never challenged or anything like that by the USPTO. It's really just that placeholder. A patent gives me a right to sell. That's not what a patent is at all. It's a patent is the right to exclude. Think about it as like a real estate. Like if you own a house and some land, you can tell people to get off your land. You can't force people to come onto your land, right? That's not what that's about. So patents are same way. You can tell people to get off your land. So I hear a lot of people say, "Oh, yeah, I've invented this thing, and now I have the right to sell this product." No, you could be infringing thousands, and probably are, frankly, thousands of patents, right? If your product's complicated in any way, think about how many patents go in your iPhone, right, and or whatever phone, and your manufacturer probably owns 20% of the patents that go into it. And the last one is, and I say this way too often: if I get a patent, I've made it. Patent is not a business plan. It's not a strategy. It likely holds very little economic value as a standalone asset. Now, that being said, I made a career out of selling patents. But just to give you real hard numbers, people would come to us with like 10,000 patents and say, which of these can I sell? The answer is usually between 3 to 5% of those would we be able to actually sell. And that would actually drive value. So most patents, frankly, are worthless. It's just the hard truth. We could push that number up if we were thinking about more of the things on the last slide, but it really goes into how much time do you want to put into it. So just a couple of parting thoughts. Think hard about, do I need a patent? What are you trying to get out of it? It's a tool, right? It's not a business plan. So how does it help you get what you're trying to do? Be very careful with public disclosure before you file a provisional. And I think deferring to what Andy said, as opposed to what I said, is probably the smart play. And be thinking about, when you're filing, every variation of your invention when you're filing your provisional. Use AI to try to brainstorm different ideas and things that you could, so that it really leaves room for you to explore as you get to the non-provisional space. And think about how you would try to design around your own patent if you were a competitor, right? Andy, I don't know if you have, I think you have some thoughts on AI specifically.
Yeah, and I just wanted to backtrack on point two. If any of you are dealing with design patents, those go under a different rule set. So provisional won't offer protection for those. So you have to be a little bit careful. Design is the look and the feel of the thing. There's a whole system for those. You can get design patents, and so if you have one of those instead of a utility patent, which is functions as something, keep that in mind. You might have to do a design filing to protect that in a similar way as a provisional for the utility patents. And then on AI, yeah, I would just say I really like AI as a tool. I would just think of it as a third person generally. And so you can ask yourself the questions. I'm telling someone about my invention. Is that a disclosure? Well, it probably comes down to, where is this AI and who owns it and what are the terms I've agreed with them, sort of analysis. The same thing goes for exporting information outside the US. We're talking on Zoom today. Zoom's a Chinese company, I think. But I think for our terms, usually they have the servers located in the US. Sometimes that stuff's important when you're talking about technical information, not transferring outside the country. I would keep the same thing in mind for AI when you're using it as a tool. You just have to be very careful as to what your agreement is with the service provider, and are they bound to keep your stuff confidential, and what sort of assurances have they given you for that? So that's my main thing. Yeah.
Awesome. I see people busy tossing questions in the chat, so let's go ahead and just jump in there. So one of the questions: how long does it take to go from provisional to full patent? I tried to throw together a timeline. I didn't show this to Andy Gabriel, so you tell me if I'm wrong. But so if you imagine, here's an example: if you file, or let's say you come up with an idea on this call and you disclose it, so you have that year, generally speaking, to file the provisional, right, application. After that year, you have another year So whenever you decided to file that provisional, you have up to another year to file the non-provisional application. That is critical. And you talk about common mistakes. I see someone asking about that. I think one common mistake is people don't file the non-provisional. And it's very important that you get that filed in a timely manner, or you lose that priority claim. And priority in the patent world is it's huge. It is absolutely huge. So if you did do the right work of getting a good priority date, do everything you can to preserve it. So you generally have a year. So you have a year to file that non-provisional. It takes 18 months from the earliest filing or date to publish the application, from my understanding. And then USPTO patent examination can go anywhere from like 2 to 5 years, I think, depending. It can be complicated. And so, Andy, did I screw any of those dates up, generally speaking?
No, I think, yeah. So we've talked about the 1 year grace period that's applicable in some jurisdictions. It publishes around 18 months. You fight with the patent office however long you do, and then if they grant it, then you get a patent that generally lasts 20 years from the filing date. Yep.
What's the biggest mistake you see after someone gets a patent approved? I'm going to throw a few out, Andy. You feel free to add on. So,
Okay.
one is not reviewing the patent at key milestones to determine if you should still maintain it. Maintenance fees come up 3.5 years in, as I guess the first one. Is it still useful to you, right? And if it's not, stop paying. I don't see people doing that review. This is more for, I would say, medium-sized companies to large-sized companies that have a large portfolio. You should actively be pruning your patents. The other is, again, that idea of I have a patent now, I've made it. Couldn't disagree more. A patent is a tool, so how do you plan on using it now that you have it? Litigation for most small companies is not in the cards. It's too expensive. There is litigation financing that's making it more approachable. But frankly, for companies that are trying to make it, the distraction that comes in is too big. That's the real cost. Is do you want to spend the next several years in depositions? And it's a nightmare scenario. So I would say, how are you going to use this in a productive way to drive your business? Can you use it for partnerships, for licensing, whatever strategy decisions? I don't see enough thought going into that. Anything else you'd add, Andy?
For after the patent's approved, I think the only thing that comes to mind right now is when you get a notice of allowance, you have the opportunity, even before that, to file a continuation application. And sometimes that can be interesting to refocus the claims because over the last couple of years you may have learned something about the landscape that you're operating in that you can use it in additional application. So that's another thing to keep in mind.
Here's a question, Andy. I'm going to toss to you.
Andy, before you jump on that next question,
yeah.
Can you, either one of you, can you put a dollar amount on each of the 6 items on this list? And don't say it depends. You can give a range, but just to give people a sense of the total cost from getting from time 0 to year 4 or 5.
So, and Andy, I'm going to punt to you. So fees plus attorney time, right?
Like the whole ball of wax type of
yeah.
Okay, so invention, I don't know, whatever your R&D costs. File provisional, the lower end is going to be a couple $1,000s. That can go all the way up to the regular non-provisional price, which is typically between $5,000 and $10,000 to get it on file. The application publishes without a fee these days. Patent examination is highly dependent on how many times you have to argue with the examiner. Each time you have to do that, think $2,500-ish in attorney time and other fees. Issue fee for U.S. patents, anyways, for small companies is on the order of $600. Don't pin me on that, but it's in that neighborhood. Plus, have an attorney do a final look, so you're talking $1,200-ish, $1,500, around there. Ballpark. And big cities cost more, smaller shops cost less. You get what you pay for sometimes.
And that's not to make another thing. there's a lot of just because they're a patent attorney doesn't mean they're good at their job, just like all jobs. So if I hire someone to pursue a patent, they're absolutely, even though they're on the prosecution side, they need to understand patent infringement. And to me, I want to know that they build claim charts that have mapped against infringing products before. That's something that I think is very valuable skill. Pursuing patents, it's a little bit like academia when you come across a professor that's never been actually in the real market, and no shade for any professors on the call here that are in that situation, but it's just you wouldn't hire them for a market assessment, right, of what's going on. And that when I'm going for a patent, I want to make sure that my patent counsel, and they don't need to be an attorney, they can be a patent agent, and frankly some of my favorite ones are they're not attorneys, they're engineers that really understand the market. They can help you get your patent, and it can just be a game changer if they know that I'm not going to put that. The USPTO is really fighting that we include this, but that's going to be a nightmare if we do. It's never going to be enforceable, or no one's ever going to walk on it. So I think we should fight really hard on this. Having someone like that in your corner is really valuable, and they're not always super expensive. It's really I'm happy to be a resource to any of you as you're pursuing patent counsel. And there's plenty that I trust, so that you would have options, including Andy Gabriel here. So there's another question, Andy, I want to throw to you before Taylor kicks us off, because I thought it was really important. Can we make significant changes in the claims from the provisional phase to the non-provisional phase?
You can is the answer. There can be some consequences to that, though, which would be primarily if you haven't adequately described the change or the delta, you might not qualify for the original priority date, and it might not come up for a really long time, which is what we started the conversation with the Railhead situation, where they added some stuff and it turned out they didn't have adequate support. So a lot of times people just go ahead and do that because it won't come up until it's challenged. But then when it is challenged, you might have some issues. So yeah, the patent office typically won't look back and say, oh, there's not adequate support. They can sometimes, I've seen it a handful of times, but typically it just doesn't come up until much later when you actually pursue and go after somebody. That's been my experience.
So that's a really good point. Just another kind of misconception about the patent system is that can I do this? Absolutely. Most times no one's watching the store. You can do lots of stuff. But if you ever need this patent and choose to enforce it, it will get challenged on all of these things that you've done. So is the priority date supportable? So the USPTO, I would say, does a very surface level job. So the real tests come later. Most patents don't get challenged because most patents aren't really used in that way. But if you ever need to use it in litigation, for example, sometimes I've seen it come up in M&A where people are doing a deep dive on patents and things like that. But in general, it's not really challenged from a judicial standpoint until litigation, which doesn't usually happen.
And just to, if the jargon is too much, what I really mean is you can do that, but it might invalidate your priority claim, which just means you'll get the date of when you first mentioned that in a filing. So that's what I mean by that.
Excellent.
Okay.
We've got a handful of other questions that weren't answered, but also like we can have an extension to the top of the hour to get through some of those questions, but also just wanted to thank anybody who has to jump off. Thanks for being here. For those of you who want to stay for an extra 12 minutes and get your questions answered, you're more than welcome to. So Andy and Andy, if you are both available, I'll keep it open until the top of the hour.
Yep. All right, I'm trying to scroll through, but if you could help me out, if we didn't answer your question, just hop off mute and ask it.
I see one. It's how can I ensure the claims are enforceable? And would a highly broad scope be a deterrent? I don't think there's a great way to ensure claims are enforceable. By that, I'm understanding you to mean they're not invalid because they're overbroad, or there's some other technical fault with them. Because again, that will be decided ultimately in court, and similar to this, the inventors working with limited time and budget, the lawyers and the patent agents also are working within those constraints to write the patents. And so they get put in the state that they get put in, they get prosecuted, you get the patent issued the way it is. And then what's going to happen if you ever go to litigation is a ton of time and energy and money will be focused on trying to invalidate this patent and trying to prop it up for the plaintiff. So it's a whole new life. And so it's highly unpredictable. Unfortunately. Go ahead, Andy.
Yeah, one of the things to think about, I've kind of been hammering on like litigation isn't something, it's expensive, it's time consuming, but that's also true for the other side, right? So that's a tool that you can use. They usually don't want litigation either, unless you're dealing with the largest of corporations who probably don't care. But most corporations do. It's a distraction for them as well. So these things that we're talking about are nuanced, right? How broad do you want your claim? How enforceable? So it's always a trade-off, right? Broad claims are wonderful to map against infringing products. It's fantastic. But the broader you go, the easier it is to challenge on obviousness, and probably there's going to be priority concerns. So it's just this balance that's always a trade-off that you go through. But do keep in mind, if you have that broad claim and you're thinking, I want to use this, but I don't want to get in litigation, there's still ways to approach that, like to do so where you're not threatening litigation, but you're still able to highlight those broad claims and get people's attention without having to go through all the challenge rigmarole.
Okay, I'm not sure if we answered that adequately, but that was a try at it.
We said a lot of words though.
Before you answer the next question, can you put your contact information into the chat?
Yes.
Please.
Sure.
And I'm really interested in Eric Godsey's questions on AI.
It's all kind of the same question of, speculating. My invention, I know it does X, or I do my example, A, B, and C. But then AI says like, oh, consider doing all this other stuff. And you throw that in, and then you have all of these different claims and wild ideas, and you may never develop some of them, if any of the wild ones. Is that good, bad, ugly, in between?
Andy, I'm definitely going to let you handle this one.
Can you rephrase real quickly? I just missed the first beginning of that because I was typing in my.
Well, the beginning was, if you throw in a bunch of extra claims and you prove that your thing, you make a proof of concept and you see, oh, this thing does A, B, and C, whatever.
Right.
You make some claims, claiming something that does A, B, and C. And then you start thinking with AI or just, you sit around drinking and trying to think at the same time. And you say like, oh, it could also be doing this other stuff. And you don't have any data for it. You're just making it up. And you're not sure if it's going to work.
Right.
And it's kind of off track from what you were doing. So you can't say, oh, my current data, A, B, and C supports these other claims, X, Y, and Z. So I'm just going to throw these claims out there and make them up because maybe AI said so, maybe my best friend's drinking buddy said so, but I'm just throwing these claims in there. How much do you have to develop those when you come time to convert to the full application? Do you really want to do? And why could that be a bad thing?
Okay, yeah, it's a good question. And I think it leads back to what Andy Godsey was talking about earlier in the talk, which is you have to have an adequate disclosure to support these things. You can have paper patents where you haven't actually made or used the thing. It's just described on paper, but it has to be described in a sufficient way that someone else could make it use it. So that's sort of the threshold. It's kind of a gray rule, and and what will happen if a challenge comes up, for example, in litigation, or the patent office will challenge some things just as sort of facially defective because you haven't described them enough. But more often it will come up again in litigation, and they'll say like, well, that's neat, but you didn't enable. That's not an enabling disclosure. You didn't help someone to actually make and use that. Someone skilled in the art couldn't read that and make and use what you're actually claiming. So that's where it would come up. They can be detrimental because if you spend time and money, each extra claim over 20 costs money in the US. You could spend a lot of time and money on getting those claims allowed just to have them be collapsed. And this might go back into the enforceable question before. I mean, that can be a reason claims aren't enforceable because they're not supported by an adequate description.
And I want to, so I don't know that so it used to be a very common trend, like, I don't know, 20 years ago, these omnibus patents, where you would try to define this crazy broad spec that would cover so much ground. And then you would file a bunch of applications off of that spec that would all claim priority back to it, which would create this giant patent family of related inventions. Those have fallen out of practice for a number of reasons. Again, Andy, correct me if I'm wrong if you've seen it in your practice, but somewhere in the middle is what I see. I wouldn't go to AI and say, help me create every idea around this. I think that's too broad. What I would say is, here's my idea. Help me understand the industries where this would be most applicable. What are the trends in those industries? How would that interact with my invention? And is my invention not sufficient in any way to address those trends? Right. So that's one way I would use AI, for example. Another way would be, I'm working with an attorney, a brilliant attorney like Andy Gabriel here. He's drafted some claims for my review. I'm going to pop that in and say, hey, I really want to focus on, I want to make sure that my claims can be infringed on. Are there any parts of this claim that you think would be really difficult to infringe, or that would be difficult? Another thing I see, there's no way people can tell whether they'll be infringed because of detectability concerns. So you can never, like, if something, for example, is like in a black box, like software, and you have no idea what's happening on the other side of that, but the claim requires that you know, that's a bad place to be. So you putting my claim in AI and saying, hey, help me understand, are there any black boxes here? Are there any elements here that you think would be very unlikely to be infringed or that are too specific? And so using it as that tool rather than like, hey, come up with some additional inventions on top of this that I can surround it with. I think that's probably too much for the current capabilities that I've seen.
And the issue of creating your own prior art against yourself if you do decide to pursue those ideas later on.
Yeah, I think that's still new ground. I haven't seen a lot on that yet as far as creating prior art with AI, but it is interesting. I'm curious to see. I don't know, Andy, I don't follow litigation trends probably as closely as you do, but
yeah, I haven't seen too much on that. At least it hasn't come across my desk. I will just say one thing about the size of the application and trying to cram a bunch of different inventions into it. That still does happen. A lot of times that's driven by economics, though, to try to get sort of the most bang for your buck in a single filing. Whereas if you had an unlimited budget, or a better budget, you might split them off into logical groupings to create a patent family.
Andy, there's a question about global filings. I'm going to adapt it a little bit. And apologies if we don't answer your question, Arjun. But so global filings. So one thing I'm just going to say out of the gate is, when you're thinking about global filings, they can be great. They can be essential. I would only file in places that have strong patent systems, right? If you're filing in a country that is unwilling to enforce or unwilling to apply a reasonable amount of damages, right, towards infringement, then what are you even doing? Right? What's the point? So that's my kind of business sense on global filings. But Andrew, any ideas or any thoughts for entrepreneurs, inventors on how to pursue global filings from an accessible standpoint?
Yeah. Yep. I think that's a good point you made. Also, so just the initial question: do you have to adapt the claims? And I'll just broaden that to the disclosure generally. The short answer is yes, you should. Different systems have different requirements. So that some care should be taken to adjust. If you don't, I think what you'll find is you could probably still get something, but you might find it to be more difficult. So on this, I would just keep foreign filing costs in mind. They tend to be higher, particularly places like Europe. The expenses stack up. So if you can imagine, you have one layer of expense for the US. If you're filing that same application across 8 or 10 different countries, then multiply by 8 or 10 what your costs are going to be. So I would just keep that in mind, budget and outlook wise. And what's the return? What's the return for that investment? It would be a question in my mind.
And I don't think any of these resources go into like PCTs or WIPO filings or anything like that, but that should absolutely be looked into in terms of how to efficiently file globally.
Yeah, I'm not sure how familiar people are, but patents are jurisdictional. So like if you file a US application that doesn't help you in Europe, you need to do something additional to get foreign rights. So that's something to keep in mind.
Yeah. There's a couple of kind of more of the primer and survey resources that you can access. There's a lot of these, so go to whatever one you want, but there's a lot of information about just generally how do I file, how do I make sure I'm doing this right. We've tried to cover a little bit more of the 300 level, 400 level questions that come up with provisionals and patents. Please feel free to reach out if you have questions. This is complicated stuff, and getting it right, even when you know all the answers, is challenging. So thank you all for coming and for your questions. We really appreciate it.
Thanks, guys.
Thanks all. Thanks, Andy and Andy, for your time today and your education. This was awesome. We'll be sending out the presentation and the recording as well. You can see that on LinkedIn also. So look forward to seeing you all next week. And thanks again for your time. We'll see you all later.